So for anyone that I have yet to meet outside of today's webinar, my name is Stephanie Morris, and I'm the director of the Refugee Alliance of Central Iowa. And we actually host a yearly refugee summit that will focus on a variety of topics and content that really just help service providers, whether you're in the field of education or health, mental health, housing, employment, legal, just anyone that works with refugee communities or families, just be able to provide some information and resources to help us all do that work a little better and a little bit more connected. So we are launching this year's summit with a webinar, the webinar today on housing and tenant rights. As we are all, I'm sure, very well aware, the eviction moratorium just ended. And so we're going to learn about both of these subjects and then specific, how that will impact our community. So with us today, we actually have Todd Schmidt from Iowa Legal Aid. And so he is actually located out of Dubuque. He has 15 years of practice around safe and affordable housing and is also the project manager for the Fair Housing Initiative Program grant out of Iowa Legal Aid. Was recently promoted to senior staff attorney specializing in fair housing law. He graduated from Grinnell in 2002 with a bachelor's in political science and obtained his law degree from the University of Iowa in 2006. And then Linda also is joining us from Iowa Legal Aid. She has been a staff attorney for the Hotline for Older Iowans since 2019. She was also a managing attorney and grant writer from Iowa Legal Aid from 1999 to 2007. She graduated from the University of Iowa College of Law in 1991 and has spent most of her time in legal aid and government work. And then from 2011 to 2019, she worked at the Iowa Civil Rights Commission as a fair housing investigator, supervisor, and then the interim executive director. So I will go ahead and turn it over to both of our panelists today to get this webinar started. And thank you everybody for being with us this morning. We really appreciate it.
Thanks a lot, Stephanie. It's good to be with you all today talking about housing. I think we've all learned in this pandemic that really there, is little that's more precious than housing and in terms of quality of life. And, it's just vitally important for our clients to understand their rights under the law. So today I'm going to be talking about some basics of the landlord-tenant laws, rights and responsibilities of landlords and tenants we'll be focusing primarily on Iowa state law. We will walk through the eviction process in Iowa. And then after I'm finished discussing those topics, we'll switch gears and Linda's going to talk a little bit about fair housing with the focus on national origin discrimination. And she'll also talk about some issues related to COVID-19. So I've listed the laws that I'll be discussing today, not so much that I'm expecting or think it's important for you to remember these code sections and chapters, but there are some differences. So, the general landlord-tenant law in Iowa is Iowa Code Chapter 562A. Most of the law that governs, the rights and responsibilities of landlords and tenants is found there. There's a different code, Chapter 562B, which applies to tenants who live in manufactured home communities, that if they own their own home and are renting the lot, there are some differences in the law. We will talk about some of those differences, but again, most of what I'll be talking about today, it concerns 562A, not 562B. And then finally, the summary eviction process in Iowa which is usually used by landlords to evict tenants. There's another longer process that in my 15 years of practice, I think I've seen used once or twice. It's that's 646, the ejectment process, but the one that's usually used is called forcible entry and detainer, and it's found under Iowa Code 648. So we'll walk through the steps of an eviction. So the first issue that I wanted to address is, who's covered by this law? Generally, transient housing, where someone might be residing for a shorter period of time is not covered by the law. So if if you rent a room in a motel for a couple of nights and then don't pay the bill, the innkeeper can remove you you don't have any of the rights of a tenant. A homeless shelter is not subject to these laws, and I've listed some of the other exceptions here. Now, with the hotel exception, sometimes obviously there are hotels where someone may stay for weeks or months or even years, and that can be a little trickier. There's not necessarily a bright line in terms of when that applies, but I think if a tenant has been paying, you would look at things like how frequently does the tenant pay the rent? Do they furnish the room? How long have they lived there? At some point, a tenant in a hotel, if they've stayed for a long time, may be considered a tenant with the rights of a tenant under the laws that we'll be talking about today. But sometimes it's not always clear. Let's talk about some of the basic duties that a landlord and tenant have. Of course, for the tenant, the primary obligation is that the tenant pay their rent on time. And when you look at the evictions that we see in our office, or if you're ever sitting in eviction court in any of the 99 counties in Iowa, the vast majority of evictions involve non-payment of rent. A tenant also has an obligation to keep the unit in a safe and healthy condition. Don't, intentionally or negligently or carelessly damage the unit, and don't disturb your neighbors by being loud such that it may impact their ability to, feel safe and comfortable in their dwelling. There may be other terms in the lease that the parties agreed on, if there's a written lease, that the tenant agreed to follow as well, and could be a basis for eviction if they don't follow the terms of their lease. What are a landlord's duty? On a basic level, the landlord should be providing a fit and habitable premises to the tenant. They should make necessary repairs when requested. They should provide the implements for heat, running water, hot water, etc., and make sure that the appliances are in good working order. The landlord also has an obligation not to abuse the tenant's access by entering the unit without permission. A landlord is required to give 24 hours written notice before entering the unit, except in cases of emergency. And the law says that a tenant can be awarded money damages if the landlord violates that provision of the code. I've set forth here the late fees that are allowed under the code. For many, many years, it was $40 a month, regardless of the rent amount. But 5 or 6 years ago, the statute changed, and what the law currently says is if your rent is $700 or less each month, then a landlord can charge $12 a day up to $60 a month. If your rent is more than $700, the landlord can charge $20 a day, up to $100 a month. A late fee would need to be set forth in a written lease to be enforceable. If a landlord has imposed an illegal late fee in their lease, then I guess it would be my position that that fee is not enforceable and the landlord isn't permitted to collect a late fee. The statute specifically addresses some illegal lease terms that are absolutely prohibited. A rental agreement cannot provide that parties will agree or waive or forego rights under the Iowa landlord-tenant law. So sometimes clients will tell me, I don't have a lease. And usually what they mean when they say that is they don't have a written lease. But if a tenant and a landlord agree on a rent amount and a periodic rental due date, the landlord hands the tenant the keys and the tenant pays the rent, and they do have an oral lease. And all of the provisions of the landlord-tenant law that we'll be talking about apply to the landlord and the tenant, even if there's no written lease. But if they do have a written lease, generally the lease cannot say that the provisions of the landlord-tenant law don't apply. You usually can't waive those. There are some exceptions to that. If a tenant is renting a single-family home. But again, generally, as a general matter, the landlord cannot try to get around the protections in the code by contract. It also is illegal for a landlord to have a provision where the tenant agrees to pay for the landlord's attorney fees. Now, the code does set forth certain claims that a landlord or tenant could bring where the other party may be required to pay their fees, but that can't be set forth in a lease. You also cannot have an indemnification clause, that says if X violation happens, then the tenant will indemnify a landlord, have sort of like a liquidated damages clause for certain breaches. As a general rule, for most breaches, the landlord's going to have to prove their damages. There are some provisions in the code that allow a tenant to receive statutory damages without having to prove actual damage, and we'll talk about that. Now, the remedy for these violations is 3 months rent and attorney fees. The catch here is that the tenant must prove that the landlord knew the provisions were illegal. So how do you do that? Typically, the easiest way to do that is if the tenant or an attorney send a letter advising the landlord that the provision is illegal. And then if the landlord persists in using those lease terms, they are on notice that the provision's illegal. So it is helpful, for example, if a tenant contacts legal aid and we do an intake, if we can see the lease and see illegal lease terms, sometimes we may send a letter putting the landlord on notice of those terms. And then down the line, a tenant may have a basis for damages. And we saw a class action lawsuit in Dubuque a few years ago that was brought by a private attorney here against the landlord in Dubuque that had illegal lease terms. Let's talk about a couple, different common issues that may arise. So what do you do if a tenant rents an apartment and they go to move into the apartment and someone's still living there? Or what's more common in my experience, maybe they go in and the apartment's not what they were shown before. It's completely uninhabitable, not livable. What can a tenant do? So the code sets out two options. A tenant could give a 5-day notice. After the 5 days, the landlord would be required to return all prepaid rent and security. So the 5-day notice would need to say, that you failed to deliver possession, and consequently, I am terminating the lease in 5 days. And the landlord would be legally required to promptly return prepaid rent and security at the end of that period. A tenant could also demand performance. They could file a lawsuit and say, if it's a tight housing market and they don't want to look for other housing, and say that the tenant, that they should be provided possession of the unit. In my experience, it's less common for tenants to choose that remedy. Usually, they will opt to terminate their lease. What if a landlord fails to make repairs while the tenant is living in the unit? In that situation, a tenant has a few different options. Frankly, the best remedy that a tenant has under the code is they can unilaterally end their lease with a 7-day notice. The notice has to apprise the tenant of the repairs that need to be made. The notice has to apprise the landlord of the repairs that need to be made. The landlord has 7 days to fix the problem. If the landlord doesn't fix the problem in 7 days, then the lease can end either at the end of the 7 days, or if the tenant wants to specify a later date, sometimes it might be cleaner to just specify if you provide the notice mid-month that it'll end at the end of the month, as long as there's enough time for the landlord to cure. And then the tenant can move without being liable for the remaining rent payments due under the lease. Now, I think that's the most direct remedy for many of our clients. That's not an option. It's difficult to come up with money if you're low income for first month's rent and a security deposit. Frequently, you're not going to be able to immediately get your deposit back. So that's not always a good option for tenants. There are a couple of other options. If it's a simple fix, the tenant can hire someone to fix the problem themselves and deduct that from their next month's rent payment. A couple things I'll say about that. It's important that, first of all, the tenant apprise the landlord of what's going on if it's not an emergency, and give the landlord an opportunity to fix the issue. If the landlord doesn't fix the issue, the tenant cannot, the repair and deduct process is only prospective, meaning that the tenant can only deduct from the next month's rent, not the previous month's rent. So sometimes tenants will say they're going to withhold their rent. That can be somewhat risky to do that, because if they withhold the rent, the landlord still could be successful in evicting the tenant. The law does provide that a tenant, if the landlord isn't making repairs, that they could file a counterclaim in an eviction case based on the landlord's failure to make repairs. We have had some success with that. I have filed those counterclaims before, but an important caveat with that is that you really need to have the rent money in hand at the hearing to have any chance of prevailing with the counterclaim. And additionally, the law explicitly says that it's at the discretion of the judge whether they'll allow a counterclaim. So it's a somewhat risky course of action, because a judge could still decide to evict the tenant anyway. And typically, you're going to have a very limited amount of time to move after an eviction hearing, as we'll discuss. Another option is to call a housing inspector. Some of these options aren't necessarily mutually exclusive. Generally, if there's an inspection department, if there are housing inspectors available, It's advisable to get an inspection anyway, to have a neutral independent observer identify any issues. Certainly, if a tenant's going to consider suing a landlord, that they could sue for money damages in small claims court up to $6,500. If they want to get an injunction to order a landlord to make repairs, that's in district court. So that's a little more of a laborious process. There aren't forms to file in district court. There's a $185 filing fee. A tenant can have that fee waived if they, deferred if they can't afford it, although the fee isn't waived. So that's sometimes an option too, but oftentimes if you don't have an inspection, it's going to be a tougher case. And so having an inspection is, oftentimes important for a tenant to assert their rights. Especially if they're contemplating a lawsuit, if they either are not able to move or it's not a minor repair that they can fix easily. Okay, now I'm going to switch gears and talk a little bit about the eviction process. So for what reasons can a landlord legally evict a tenant? There are several reasons laid out specifically in the code. If an individual is not really a tenant and they're squatting in a building, but without the consent of the landlord, that could be a basis for eviction. Typically, the individual isn't entitled to any notice before a case is filed if the landlord's asserting that they entered by intimidation, fraud, or stealth or force. A tenant may have held over. So, for example, if a tenant has a month-to-month lease, which an oral lease where neither party signed an agreement is by default going to be a month-to-month term, then a landlord could give a 30-day notice for any reason or no reason at all, so long as the termination of the lease is not based on a discriminatory reason, as Linda will talk about. If the tenant holds over after that termination notice is given, then a landlord could give a 3-day notice to quit and file an eviction. The landlord may be alleging a material violation of the lease, which is one of the terms of the lease. If a tenant is violating that, we talked about some of the tenant's obligations, disturbing quiet and peaceable enjoyment of neighbors, damaging the property, etc. Or there might be a specific term in the lease, such as a no pets policy, and that would be a basis for a landlord to evict. They would use a 7-day notice, similar to the process a tenant would use if the landlord is not making repairs. Non-payment of rent, as I said, is the most common reason for an eviction. And then finally, clear and present danger. If a tenant is posing a clear and present danger to the landlord or their neighbors, that could be a basis to evict. And that's a pretty harsh remedy under Iowa law, because unlike most of these other bases to evict, typically a tenant doesn't have a right to cure in that situation. The code provides some examples of clear and present danger. Generally, it's referring to violent or drug-related activity, although the code does not indicate that that's necessarily the only things that could constitute clear and present danger. The limits of that are somewhat unclear in the code, but usually, again, we're talking about an assault or use of drugs in the apartment, and the landlord is evicting the tenant for that reason. Now, it is illegal for a landlord to retaliate against the tenant for asserting their rights. So if a tenant contacts a housing authority alleging a failure to make repairs, or if the tenant either complains to a landlord about their failure to make repairs and can document that. There is a presumption for a year after that complaint that if the landlord does try to terminate the tenant's lease, that the reason is in retaliation. So as we talked before, typically a landlord can give a 30-day notice for any reason or no reason. If a landlord gives a 30-day notice and the tenant's made a complaint within a year, then the court is going to presume that that termination is in retaliation for the tenant complaining if the tenant can establish evidence of a complaint. And that is a presumption that the landlord could override if they have evidence for some other reason for the termination. But, unlike a normal holdover case where a tenant may, be holding over and the landlord doesn't necessarily have to prove anything to show that the termination is valid. In this case, the court will presume that. Now, an exception to this is if the tenant's behind on the rent, that this is not going to be a defense. So this would only apply to a termination based on one of the other reasons that I just talked about. I previously talked about a counterclaim a little bit, and it looks like I'm kind of running out of time here, so I want to keep going along. So let's walk through the eviction process and the steps of the process. Now, the first step in the process is it happens in almost every case, a landlord's going to have to give a written notice before the eviction takes place. So for a non-payment case, the landlord has to give a 3-day notice to cure. So the notice has to say, pay your rent in 3 days or move. Now, a lot of times I think tenants will see these and they're very blunt and harshly worded, and that's contemplated by the code. Does this mean what the question that tenants will often have is, so do I have to move, or what's going to happen if I don't move? So, it's a 3-day notice to cure for non-payment, 7-day notice to cure, as I said, for material violation, and a 3-day notice for clear and present danger. If a tenant gets that notice, if they move or do whatever is necessary to cure before the period to cure is up, then there won't be an eviction case. But if they don't move, the landlord is still going to have to file this process that we're talking about, file this case that we're talking about, which is oftentimes referred to as a forcible entry and detainer case. And only after the tenant has an opportunity for a hearing and going before a judge, and a judge orders an eviction, can the tenant actually be evicted. So that's very important. And these notices, if it's a notice to end someone's lease, they've got to be served specific ways too. So the landlord either has to have personal service by a sheriff or process server. The tenant can accept service by signing the notice. And to be clear, a tenant's under no obligation to sign for a notice. So if a landlord's at their door demanding that they sign something that they don't understand, they can and should say no. And then finally, a landlord could serve the notice by regular mailing and posting. And they also have to send the notice by certified mail. And if it's mailed, the law says it takes 4 days from mailing to be received. So the cure period starts at the end of the 4 days. After the landlord gives a notice, if the tenant doesn't fix the problem, or if it's a notice to quit and the time lapses, then a landlord can file an eviction and small claims. The tenant must be served with an original notice by the same methods that we talked about before: personal service, acceptance of service, mailing or in posting. Then the next step is an eviction hearing. Typically, this is set about a week after the case is filed. Typically, how it should work as a threshold matter, the landlord will consider what notices the tenant has been given. And if the tenant hasn't been given proper notice, then the landlord, then the judge should dismiss the case. And this was a very important case that Legal Aid did back in the early 90s, where it used to be some magistrates would say, well, if the tenant could not have fixed the problem, then it didn't really matter if they got good notice or not. And the Supreme Court decided that no, proper notice was jurisdictional. So sometimes judges will refer to the notices as jurisdictional documents. And if the landlord cannot establish that they gave proper notice, then the case should be dismissed. And really the court shouldn't take any evidence at all from anyone. There shouldn't be a hearing. But if proper notice was given, then there'll be a hearing. The landlord will present the reasons for the eviction. The tenant has an opportunity to respond, call witnesses, present exhibits. If ultimately the magistrate decides that the tenant broke their lease and should be evicted, the magistrate can really only give 3 days for the tenant to move. So, in many ways, this is a very harsh process. Sometimes I've heard landlords call this a tenant-friendly law because oftentimes, many of the magistrates, in my experience, will require strict compliance by the landlord with the law before they evict. But a tenant could be, in theory, be a day late on the rent and get a 3-day notice, the day after the rent was due. And if it's personally served and they fail to pay, they could be evicted within 2 or 3 weeks after the rent was late. So in many ways, it's a very harsh process. Self-help evictions are absolutely illegal in Iowa. Landlord can't just lock out a tenant or turn off the utilities because they haven't paid the rent. And the law does provide, if a landlord takes self-help measures, that the tenant is entitled not only to their actual damages, but punitive damages of 2 months' rent and reasonable attorney fees. So that was another change in the law that occurred a few years ago, and I think did help a lot, sort of that thread of reasonable attorney fees. It used to be, I think, just actual damages were available. And I think, it's certainly in my experience, it's been easier to, if a landlord does take self-help measures, to get them to reverse course, knowing that if they get sued, they have to pay the tenant's attorney fees. And then finally, there's a provision in the code I just wanted to highlight that says that the tenant has a right to call for emergency assistance. So if landlord is trying to evict a tenant because they're a victim of domestic violence and they've been calling the police, it's illegal for a landlord to evict a tenant for that reason. Does anyone have any questions?
This is Stephanie. I see a question in the chat about evidence of a reason of eviction. It says they've seen cases where a landlord will allege noise or something along those lines where it seems like there's actually a different foundational reason. So what does the landlord need to actually show as evidence for the reason of an eviction notice?
Yeah, and some of those, some of those cases can be difficult. We've seen this a lot more during COVID, because for a lot of the period during COVID, a landlord has not been able to evict for non-payment of rent. So you'll see landlords ginning up other reasons. And it's kind of hard because this is a summary process. You don't know necessarily what evidence is going to be presented by the landlord until you get to hearing. I guess then to answer the question, I would say, the burden of proof for the landlord is a preponderance of the evidence. So the judge does have some discretion. So, I think that I mean, it's a little looser in small claims than it would be in district court, where, you know, frequently you have a landlord there that may not be represented by counsel. There are a lot of self-represented litigants, a lot of tenants not represented by counsel. So the court isn't always, doesn't necessarily, maybe doesn't strictly enforce the rules of evidence in the same way that they would in district court. But in terms of what evidence is needed, well, I mean, I think that the judge would consider any witnesses or documentary evidence provided. Now, what if you have a case where the landlord says the tenant's making a lot of noise and the tenant denies that? I think it's the landlord's burden of proof. If the landlord's evidence is based purely on hearsay, that's possibly, I mean, I would challenge that and say the landlord hasn't met their burden of proof. Certainly if there's a pretext, that's something that a tenant could assert. And I don't know, maybe this is a good segue into Linda's part, because I think that, if a landlord is evicting someone for noise, but the real reason is because they're discriminating against someone, then, I think that would be a defense to the case if that's the landlord's true motivation. And just, the difficulty there is establishing that. So I will turn it over to Linda, since it looks like we're
That's okay.
almost 40 minutes in here, but.
Okay.
And I guess I'll unshare mine.
You
And
unshare yours, and
let's see, do that. Stop share. All right, there we go.
Okay, now I have to figure out how to share it. Okay, please be patient with me as I. Why am I not? Oh, okay. Is it? I am sorry, I'm having problems. Oh, there. Share screen here. And there. Can everyone see it now? Okay.
No, actually, we're seeing your calendar right now.
Oh, you're seeing my calendar right now. We don't want to do that. Yeah, on my screen, it says that you can see it. You're not seeing anything. Okay. Sorry about that.
Linda, do you want me to share from my screen?
Did it work now?
Yes.
Thank you. Thank you very much. Okay, sorry about that. You would think after all this time and I would have learned. So, okay. I am now. Oh, I see what's happening. Okay. There. Okay. I will be looking at a different screen, so I hope you're not watching. I'm going to just talk about the screen, about that. So, well, this part is about fair housing. The last half, to those of you who maybe missed the introduction, I'm Linda Grathwohl. I'm also a staff attorney at Iowa Legal Aid. I work at the legal hotline for older Iowans. And to follow up on Todd's presentation, we're going to spend this time talking about fair housing, and we'll talk mainly about the Fair Housing Act, or also known as Title VIII of the Civil Rights Act, the Federal Act, and then the Iowa Civil Rights Act of 1965, which closely follows what is in the federal fair housing law. Let's see. When we talk about what discrimination is in housing, I often, when I talk to clients or others about discrimination, everyone knows discrimination is different treatment. What some people forget to focus on is that it's discrimination based on being a member of a protected class. And that we'll be talking about what the protected classes are in just a moment. There are two different theories of discrimination when you're trying to prove it. Is that we're most familiar with disparate treatment. That's the different treatment of someone because of being a member in a protected class. Disparate impact is a little bit more difficult to prove, but it's when there's a neutral policy, but it ends up having a discriminatory effect on a protected class. I give two examples of that. If a landlord is requiring that a tenant who receives child support isn't, accepted as a tenant, that could be discrimination based on familial status or gender, because that, especially mostly women, receive child support to support their families. Another example is criminal history. A neutral policy of preventing any tenant to have a criminal history may look like it's neutral, but in Iowa, where we have a higher proportion of African American and Latinos being arrested, having a criminal history, this neutral policy can have a discriminatory effect on a protected class. And I believe, and these are the protected classes we're most familiar with: race, color, religion, creed, sex, national origin, familial status, and disability. The Iowa Civil Rights Act goes a little bit farther than the federal fair housing law by also protecting sexual orientation and gender identity. So people in these protected classes are protected by the fair housing law. And then also the fair housing law covers a wide variety of types of housing, not just apartment buildings, rental housing, but it also extends to homeless shelters, student housing, farm worker housing, nursing homes. There are a number of exceptions, such as the Miss Murphy or Mrs. Murphy exception. It's like if they're more than, somebody rents out, 4 or less rooms to tenants, that may not be covered by the fair housing law. Also, there are some other exceptions, such as senior housing. There are certain types of senior housing that are exempt as in regard to familial status, that protected class, because there's like 55 and older and 62 and older housing. Then, and these are the discriminatory practices that are listed in the Iowa Code and the Federal Fair Housing Act. Most of them are very familiar with: the refusal to rent or sell to someone, a different treatment in the terms and conditions of sale or rental, discriminatory advertisements, residential real estate related transactions. That means you can't discriminate in the buying of a house. Many of the last ones I have listed have to do with protection, the protected class of people with disabilities, the failure to provide reasonable accommodation or reasonable modification in order that people can enjoy the premises. Often with reasonable modification, we see that with somebody asking to add a wheelchair ramp to a house so that they can access the rental unit. Reasonable accommodation is when somebody's asking for a waiver of a policy, practice, procedure, or rule. We often see this most commonly with requesting assistance animals and a waiver of the no pets rule. There are also many rules and laws regarding design and construction of multifamily dwellings to let people access because of disabilities. Redlining, block busting, steering, having to do with segregation of not allowing, redlining of not allowing people to have access to the credit so that they can purchase homes in certain areas of cities. That's something that started in the 1930s and can continue up to this day. Blockbusting and steering is, trying to isolate people, saying, well, either in steering, you aren't going to like this neighborhood or you won't feel comfortable here. Again, perpetuating segregation. And then also the fair housing law deals with prevention of harassment, especially sexual harassment. And then is also, as Todd talked about, it's illegal to retaliate against someone because they they asserted their civil rights by filing a civil rights complaint or assisted somebody else in filing a civil rights complaint.
Hey, Linda, we have a really quick question about.
Oh, sure. Yes, please
source-
ask.
Yeah, the source of rent. So someone had asked if it's possible for a landlord to just to not accept a specific payment. So they had said because of the client's involvement with a specific nonprofit, so like a domestic assault support group or immigrant support group, is that legal? Because they have seen landlords state explicitly and refuse to accept funds for deposit or first month's rent from these supportive agencies.
That is a good question. I'm going to ask Todd if he has an opinion about that. That's a difficult, that it could be looked at as discrimination. I don't know if you can require a landlord to accept it from certain agencies. Todd, have you had any experience with that?
Well, I think that there could be fair housing implications. I currently am involved in a lawsuit in federal court where we sued a landlord who wouldn't take housing choice vouchers, which we had requested as a reasonable accommodation. And the theory was that my client had disabilities and wasn't able to work, and the landlord had increased the rent. And so she could no longer afford the rent and asked the landlord to take her voucher, which would have allowed her to afford the rent, and the landlord wouldn't accept it. So we're awaiting a decision from the judge in that case. So I think that will give us more of a sense of whether that's a viable argument. I mean, I think in terms of funds from a domestic abuse shelter, that's an interesting issue because it seems like there could potentially be discrimination based on sex if a landlord won't accept it. But I think that that's certainly kind of an issue that's hasn't been fully explored by the courts, I would say, and there probably is an argument, but it's certainly not clear cut at this point.
And I'm hearing from a lot of clients, because they're applying for rental assistance during the moratorium and after the moratorium, and there's some landlords that refuse to cooperate, like with Iowa Finance Authority or other agencies. And I don't know if you could show that as discrimination, but it may be, as Todd was talking about earlier, could be a pretext, especially if you could show that the landlord accepted rental assistance from someone else who's in a different protected class, like accepted rental assistance from a man, but not from a woman. Well, then you've got the fair housing complaint. Then I'd say call your local civil rights agency or the Iowa Civil Rights Commission to file a complaint, or HUD. So.
Yeah, I mean, just one more thing about that. So I mean, we have certainly encountered landlords that wouldn't take assistance from IFA, and some jurisdictions have source of income ordinances. So we've argued that so some municipalities have said you cannot discriminate based on source of income. Iowa City and Des Moines are the most prominent examples, and so we had argued in those localities that a landlord wasn't permitted to turn down IFA assistance, although then in the last legislative session, the state basically stripped localities of the power to have such ordinances. So, I think that's not going to be an argument going forward. Certainly it's important. I mean, that's a good point. You know, if the landlord doesn't take any sort of rental assistance, it may not matter if it's from a domestic violence program, but if they're taking other forms of rental assistance, but then they won't take assistance from a domestic violence program, I think that's just disparate treatment potentially. But yeah, it would, I think, kind of depend on the specific circumstances.
Right. Yes. Any other questions before I go forward? Oh, I was going to look. Okay, well, I'm going to go forward then on specifically on national origin discrimination, which again is different treatment in housing because of a person's ancestry, ethnicity, birthplace, culture, or language. And here are some examples of national origin discrimination. Refusing to rent to people whose primary language is not English, or steering buyers or renters away from certain neighborhoods. When I was talking before about segregation, because of steering people away because of their ancestry, or failing to provide the same level of service, or because a tenant was born in another country. And here we have in this portion, I will try to do as many as I can, some scenarios. Here is one about somebody who was born in Guatemala, tried to lease an apartment, and then filled out an application. When she showed up to fill out an application, the landlord's attitude was very different, and then got a letter denying the application saying she got a negative reference. Well, she was surprised because she never had problems with her landlord, and she even checked with the landlord and found out he had never been contacted. Has that prospective landlord violated fair housing laws? Yes, the landlord appears to be discriminating based on national origin and/or race. And this is based on a HUD settlement from 2018, where they found this type of discrimination based on applicants' race and national origin. And so I have another scenario here. Management of a community is requiring everybody to provide a copy of their driver's license.
So Linda, I don't know if you saw, but we do have to wrap up, and we do. No,
Okay.
I mean, I don't know if you saw Stephanie's message. We are going to have to
No, it
wrap
did
up.
not. Okay.
So we have to wrap up in 5 minutes. So
Okay, then I'm going to
you
skip
decide what you want to
away.
focus on in that period. But
Okay, thank you. I did not see that message. Thank you. Okay, well, I think we're going to make these slides available through the PDF, right, Todd? Yep. Okay. Then I'm going to skip through the scenarios and that are undocumented persons protected by the fair housing laws? Yes, they are. Whether you're a citizen, legal permanent resident, or undocumented, you're protected by the Federal Fair Housing Act. And I'm going to skip the scenarios. And then again, the segregation is illegal. It can look at like discouragement. And then also I want to talk briefly about that HUD has issued guidance about limited English proficiency, because sometimes discriminating based on lack of English can be a proxy for national origin discrimination. So like requiring every tenant to speak English or turning tenants away. And you will have, and I don't know if I don't think I even have time to talk about fair housing and COVID, but that short version, COVID-19 can be considered a disability under the Iowa Civil Rights Act and under the Federal Fair Housing Act. And it is illegal to discriminate against tenants based on generalized stereotypes, that they're more likely to contract COVID or ask about COVID, having COVID, or prohibiting a caretaker to take care of someone. I'm just going to stop there and ask if there are questions since I kind of rushed through this and I should have talked faster. Are there any other chats or anything? Any other questions? No, I think I have 10:57, so we'd have time for some more. Otherwise, I could just, any other questions for Todd? Do you have anything else? Oh,
So I
am
mean, I
getting-
think maybe one thing we could talk about is, you know,
Okay.
if there are, what if someone that, what if someone who's undocumented or someone
Mhm.
who's an immigrant feels that they've been discriminated against? What should they do about that?
Yeah, they can, I mean, they have options of filing a civil rights complaint. There's some cities in Iowa that have their own civil rights commissions. You can people have contacted Iowa Legal Aid for help with that. Also, the Iowa Civil Rights Commission takes complaints. There's a phone number to call or I believe there's online application. Also, the federal Department of Housing and Urban Development, HUD, there's an office in Kansas City that takes complaints from individuals. What happens is when a complaint is filed, the person's interviewed, the agency usually drafts a complaint, and then there's an opportunity for mediation, and complaints can be investigated and can go on for further litigation. Do you have anything to add to that, Todd?
Hey, Linda and Todd, this is Stephanie again. I just wanted to add in that, the Iowa International Center does have a emergency housing hotline that people can use to get somebody on the phone that can interpret in most languages. So tenants can use it and landlords can use it on both sides. And then also, I know that there's like Polk County has a couple of different websites and resources. We have shared a lot of that on the Rossi website as well. But I wanted to ask, so if someone feels that they definitely have something that has happened that constitutes discrimination, they need legal assistance, how can people get in contact with you, with either of you or Iowa Legal Aid in general?
Okay, Todd.
So there is a general intake line. We do have our, quite frankly, we have a special fair housing project. Our email addresses are available. So if you're on the front, I've provided a PDF of this PowerPoint to Stephanie, so I hope she can disperse this to everyone. My email address is at the beginning. So if you're an advocate and you have questions about whether this is a case we could handle, I'd encourage you to just email me directly. If you look up Iowa Legal Aid online, we have online intake and phone numbers for intake that are available there as well. We do phone intake every day in the morning and afternoon, except Thursday afternoons. You can do an online intake at any time. But again, if this is something where you have a client and just want to check and see if this is something that we could handle, I'd encourage you to reach out directly. I think that's fine. And we are going to be we've been doing more fair housing enforcement work recently in the last couple of years than we did. And I think that that's, likely to increase in the coming year. We're starting a new enforcement project here in the next month or so. So I would be interested in hearing from people in terms of what they're seeing. Back to that initial question about what if it's a pretext? How do you establish that?
Mhm.
I think that's part of how the complaint process can be used as a tool for tenants is it can be hard to prove discrimination. What's really going on when a landlord takes action against the tenant, and the Iowa Civil Rights Commission complaint process, it's totally separate from legal aid. But an investigator will interview all the parties and to try to figure out what's happening and issue a report. And so that's basically a free investigation that could benefit the tenant. So I think that's a reason to file a complaint and participate in the complaint process. It's essentially someone will interview the complainant and their landlord and any other relevant witnesses and determine if the landlord is discriminating. And that's something a tenant could use in a lawsuit. They could use to fight an eviction. And sometimes it can be hard. The difficulty with evictions is that the process is very fast, and whereas a civil rights complaint, can take a few months. But I mean, certainly I've had cases where a tenant had a pending complaint and the landlord backed off until the complaint process was finished, because, they knew that if they proceeded aggressively with an eviction and were found to have discriminated, then, the damages that a tenant could be awarded were likely to be a lot more by virtue of the fact that they, had evicted the tenant. So.
Okay. Does anybody have any last minute questions here? And again, we will have a recording of this available on the Rossi website. It'll be housed there moving forward. And then we will definitely be sending out the PowerPoint that both Linda and Todd were referring to during today's webinar to all of the registrants as well.
Okay.
Well, thank you very much for the opportunity to speak to you.
Yes,
today.
thank you. Thank you very much.
Thank you both so much for your time and all of the work that you do just on a day-to-day basis. We're very grateful. And I know that there's a lot of people that were on the call today that were very happy to be here and to be able to get this information out into community. So thank you so much.
Thank you.
Thanks to all
Bye.
of you as well.
Thanks.
Bye.
Thank you.